Madam Deputy Speaker, the end of the Right Honourable Gentleman's question belied the beginning of it, because the end of his statement showed the absolute consistency between what I have said in my representations to the court and the case that I have made to the House today. And the issue at hand here is a simple one, that highly classified information was sent over by the US. It's highly classified because of its contents. But the point at issue that I and the court had to address is that intelligence sharing is based on a principle. It's based on the nature of the relationship that we have. And the nature of that relationship is not dependent on one cable or another. It is dependent on the fact that if another country cannot have confidence that its secrets are safe with us, then it will not share its secrets with us in an open and transparent way with the relevant authorities. In the same way that I'm sure if our secrets were disclosed in a foreign court, dare I say another European court, against our wishes, he would be up in arms, rightly in my view, protesting against the invasion by a foreign court of our rights to keep our sources secret. And I believe if he reflects on his own position and not just mine, he will see that the inconsistency is his rather than mine.
Mr. Keith Bowes.
Can I thank the Foreign Secretary for his statement and the strenuous efforts made by the government on behalf of Mr. Mohamed. He's mentioned several times the investigation by the Attorney General. She has now had this before her for the last 3 months. In view of the public interest in this matter, can either he or the Home Secretary contact the Attorney General to see whether it's possible to complete this process as quickly as possible?
Madam Deputy Speaker, I'm sure the Attorney General will not have failed to notice the public interest in this case over the last 24 hours, and nor will she have failed to notice the representations that my right honourable friend has made today. But in case she has failed to notice them, I'll be sure to draw them to her attention.
Mr. Charles Kennedy.
Following on from that question and the two earlier on exactly the same point, why doesn't the Foreign Secretary just confirm today that when the government receives the advice from the Attorney General that the Home Secretary sought on October the 23rd, they will make it available to the ISC and they will make it available to the House and indeed the public generally, given what is now the public nature of this entire process. And on that issue, incidentally, we're also waiting to hear from the government in terms of the recent Information Tribunal ruling against them again, in terms of making the then Attorney General's advice and the Cabinet minutes relevant to the decision on the war in Iraq. Is the government intending to appeal that to the High Court or to apply a veto under existing freedom of information legislation?
Order. I think the final remarks of the Honourable Member are beyond the scope of this statement. Mr. Secretary of State.
Well, as the Right Honourable Gentleman says, worth a try, but I think probably not worth a response. In respect of the, we'll come back to that on another occasion. In respect of the early parts of his remarks, it's dangerous for one non-lawyer to tell another non-lawyer about the legal situation, but he referred to advice from the Attorney General. That's not actually correct. The Attorney General has to decide whether there is a case for prosecution. And so it's not a question of whether or not advice should be published, it's whether or not steps should be taken on the basis of a decision by the attorney as the highest legal authority in the land. I hope he wasn't under any misapprehension about what I said earlier, which is that the government's commitment to the ISC, which has been repaid in full by the ISC in the way it's treated the information that we give it, is to be full and open in our disclosures to the ISC, and where information is of a highly sensitive nature, it's not published, but the ISC do see it and scrutinise it, and that must be the right way of working.
Andrew Dismore.
Would my right honourable friend, in relation to the potentially exculpatory material to which he referred, at least go this far to say in general terms whether that included evidence of torture? Because if so, that would fit the pattern of the very cogent evidence the Joint Committee on Human Rights received on Tuesday afternoon about allegations of torture by the Pakistan security services and the complicity of UK agents in that. And whilst my honourable friend may see no evil and hear no evil, that doesn't mean to say the evil of torture doesn't exist. And would he ensure that the JCHR gets full cooperation in our inquiry into UK compliance with the requirements of the United Nations Convention Against Torture in these matters?
Madam Deputy Speaker, I'm sorry if my honourable friend sees the referral of an allegation of mistreatment to the Attorney General, the highest authority in our land, as a hear no evil, see no evil approach. Because in fact, the suggestion of the evil of torture is what has prompted the referral to the Attorney General, and the Attorney General can then decide whether or not there is a case for criminal prosecution of the individuals involved. So far from this being something that is going to end up on a shelf, it's something where the Attorney General can decide where to take it. In respect of the earlier parts of his question, I think that he showed through his own question that this is an extremely complex area where broad brush statements have to be chosen with great caution. I think what I should say to him is that the material is highly classified, and that the aspects of complicity in torture or elsewhere are published in the appropriate legal documents, and I would refer him back to those.
Patrick Mercer.
Most grateful, Madam Deputy Speaker. I wonder if the Foreign Secretary will, of course, be aware that Mr. Binyam Mohamed is one of, I believe, 2 British residents still left in Guantanamo Bay. Now, there are suggestions that the other several dozen prisoners should be removed from United States soil and dispersed around welcoming countries elsewhere. Could the Secretary of State tell the House what the British government's position is on this, and whether this government has yet received any requests from the Obama regime?
Madam Deputy Speaker, we haven't received such a request. When I spoke to the Secretary of State, the new Secretary of State, on Tuesday, I explained to her what we'd done, that we were expecting 2 further former British residents to come back to the UK, that, in the words I used at the European General Affairs Council last week, we had done our bit in bringing back 13 and up to 15 residents, but that we did want to play our part in helping other countries fulfill their commitment to help the United States close Guantanamo Bay. And so I promised to my European Foreign Minister colleagues last week that we were happy to share our experience of bringing those people back, and that's something that I can tell him already a number of European countries have asked for our help on. It's something that we want to help them do, because they recognise their need to help the Americans close Guantanamo Bay.
Anne Clwyd.
The judges argued yesterday that it was, in their view, difficult to conceive that a democratically elected and accountable government could possibly have any rational objection to placing into the record a summary of what its own officials reported as to how a detainee was treated by them. Now, I know the Foreign Secretary has said he's spoken to Hillary Clinton, but is he prepared to ask President Obama personally for permission to release this information? Otherwise, people in this country will continue to question the secrecy that surrounds this decision.
Madam Deputy Speaker, my right honourable friend shares with the government a very strong commitment not just to uphold human rights around the world, but also the belief that where there has been error, there should be openness as a way of trying to, at least in part, remedy it. However, she asked what are the circumstances in which continued secrecy is appropriate. It's where sources would be compromised by their release. And it is for each country to determine the circumstances in which public release, not release to the Defence Council in any case, but public release would prejudice that position. And I think that that is the right and pragmatic approach to take to this case.
Andrew TYRIE.
Thank you, Madam Deputy Speaker. There are several paragraphs in this judgment which I think it's extremely important that we should all bear in mind, particularly the Foreign Secretary. They say, and I quote, "It is difficult to conceive that a democratically elected and accountable government could possibly have any rational objection to placing this in the public domain. We do not consider that a democracy governed by the rule of law would expect a court in another democracy to suppress evidence of allegations of torture, politically embarrassing though that may be." Will he therefore act on the suggestion of my right honourable friend, the Shadow Foreign Secretary, and ask for a specific exception to be made in this case of the US administration?